Good morning, this is Nicole Norris reporting for the Redheaded Black Belt, kimkimp.com in San Francisco. We're at the Ninth Circuit Court of Appeals and it is April 9th. The Institute for Justice is here on behalf of the victims of the Cannabis Abatement Program, and they just did their opening statements in front of 3 judges this morning. We're here with Jared McLean from the Institute for Justice, the lead attorney, and we're going to talk to him about how he felt today went. Good morning, Jared.
Hey.
Thanks so much. How do you think things went today?
We're cautiously optimistic with how things went today. I think just like as a primary matter, it was nice for our clients to finally get their day in court. They've been waiting over 5 years for an administrative hearing with the county. The magistrate who at the trial court level dismissed our complaint without letting us come into court and argue our position. So it was refreshing to finally have some judges sit there and ask us questions and listen to what we had to say.
Yeah, I mean, what can be said about the fact that the local trial judge didn't even give you like opportunity to do an opening statement like this?
Yeah, I think that I think that the argument today showed that the judges were concerned with the way that the trial judge just rejected all of the allegations in our complaint. The way this is supposed to work is that we allege that something happened to us, what happened to our clients, that they got these cannabis violations when they hadn't grown cannabis, and that then they never get hearings, and the trial judge is supposed to accept that that is true and decide whether or not it violates the law. And he just refused to accept that the county would ever behave this way. It was wrong for the trial judge to do that, and I think it came across in today's argument that the panel at least seemed concerned. Whether or not they'll ultimately agree, we can't say, but they at least seemed concerned with the way that the trial judge handled our complaint.
What shocked you most about today?
I don't know that any of the judges' questions shocked me, but it was a little surprising to hear the county stand up and repeat the misstatements from their briefing, from their motion to dismiss. After, in our briefing, we had pointed out the ways that they were misrepresenting the facts or the things that they were missing. And then they stood up today and they still just repeated it all. So that was a little surprising and a little disappointing.
So nothing really came out of their arguments that hadn't come out before, right, from the county?
There was nothing new here from the county that I noticed. It's been pretty much the same since we first filed our complaint. Their position is that this has everything to do with cannabis, but it also doesn't, when they don't want it to have anything to do with cannabis, this is just about permitting violations, and there are unpermitted structures on our client's property, and it's been the same bait and switch all along, and that continued today. I was a little surprised by the county's response to, so the judge asked the county, he said, do you record these violations against the title? And she tried to say first that these were just new violations, even though that they had existed for 2 years prior and they just never recorded those violations against the code. And then she said it was our client's fault that Rhonda and that Doug and Corrine Thomas, that they should have looked at that garage and knew that garage was cannabis-like, and they should have known that by buying a property that used to have cannabis on it, that they would just face $1 million in penalties and a $200,000 disruption order. And that's just not the way the law works. It's not the way the world works. So in their briefing, they agreed. So like we allege in our complaint, we say, hey, they're just singling out areas, and they're saying that based on your proximity to someone who might be doing something wrong, we're going to also charge you with violating the law. And we pointed out how that's a problem and how there's Supreme Court precedent that says that violates our clients' rights to due process. And the county said in their brief, they said, yeah, but this is a vast mountainous land, and like we can't really investigate all of it, so this system just makes more sense, and county law allows us to do it. But this whole case is about whether county law complies with the United States Constitution, and they didn't say anything today or in their past briefing that would change that.
Beautiful. Thank you so much, Jared. Do you have any other final thoughts at all this time?
No. Thanks
so
for
tomorrow
down.
Something's going to happen, right?
Oh, it could be months.
Okay, months.